How has startup training been going, Beth?
It's been going really good. This is my second one and they've been really informative so far.
Awesome. I love to hear that. Tell me a little bit about your business. What are you working on? Or what are you thinking about working on?
Well, I am an artist and I do anatomy art and I've been doing that for a couple years. I just started teaching classes and that is going really well. So I'm thinking about like expanding in that area, which I've never really considered before. So,
It's so funny because my brain, I'm a mom. I've got an 8-year-old and a 5-year-old. And I instantly am like, birthday parties, like experiences, like get people together for a painting class, like bang for buck, Immediately that's where my head went. It's like, okay,
yeah.
anatomy art probably isn't the sexiest child's birthday party, but basic colors, color wheel, mixing, textures, things like that. Like, you know, uh,
Yeah, I teach all kinds of art, not just anatomy art.
cool, cool, cool. Well, we're excited to have you. It's really nice to meet you.
Thank you.
Of course. Hey, Lily S., how are you doing?
I'm good. How are you?
I'm so good. Thanks for joining us. How's start of spring training going for you?
I had a little hiccup this morning. I accidentally clicked out of the Zoom while checking a message, and then I couldn't get back in. So I was like, "Oh no!"
Ooh.
And then I was dealing with some resume updating just because um it's funny because I joined spring training thinking that I was going to focus on figuring out how to brand the natural talents that I've developed over the years.
Yeah,
With like a deep cleaning and extreme organization, space reconfiguration.
yeah.
And then I was like, you know what? Like, no, we've already told ourselves we're going back to school this year. And I'm actually wanting to go to school for cybersecurity. Um, and I want to open up my own female owned and ran tech and security firm. So I was
That's
like, well,
awesome.
it looks like my micro grant is actually going to something else because like timeline wise, it just doesn't make sense to try to open up a business about something that I'm naturally good at and enjoy, but isn't the long term picture, especially when like in order to get my certificate, it's only going to take me 2 years. So I'm like,
Love.
okay, we're going to start developing the new business plan.
That's great. What a safe space for you to launch it. We have an alumni. His name is Damilare. And he believe he is leading a session. He has his own cybersecurity business. Um,
Hmm.
so be sure to sign up for his session and be able to connect with him and ask him questions. He offices out of South Phoenix. He's at a little office space called Galvanize. And he's wonderful and super knowledgeable about all things cybersecurity and runs his own company. So be sure to connect with him throughout this program.
I definitely will. I noticed there was a chat GBT one and a security one, but I didn't realize um that we had someone who kind of like specialized in the area. So
Yeah, yeah, he super does. And he's wonderful. The chat GPT is like how to leverage basically AI for optimization of business, which everybody should know how to do that at this point because the robots are coming. Let's accept them. And let's use them for good. And then, but yeah, cybersecurity, I think, is going to be a really a one of interest. All right, we're going to go ahead and get started. We've got a room filled with amazing humans. I'm super excited to meet you all. My name is Tristan. I'm the VP of Programs for SeedSpot. And you are successfully not only enrolled, but participating in your first week of Startup Spring Training. Can we get a hoot? Can we get a holler? Is it me by myself? I'm the only one happy for you? Come on, come off mute, be interactive. Today, we're going to talk about the art of contracts. And we have this session this very first week. It's a treat for you guys. And here's why. These are the things, thank you. I'll take the chat hype up, I'll take it. These are the things that entrepreneurs often forget. Right? We start our businesses because we love doing the thing or we have a certain talent and we forget about the contract part. We forget about the legality of it until we're in some hot water. So our hope is that we can get ahead of it today. We can get our ducks in a row. You guys can ask questions. This is an interactive session. So we have a chat feature. If you have any questions at any time, I'll be moderating the chat. So I need you to go ahead and pop your questions in the chat. And I'll say right now, if you have chats or questions before the session starts, you can put them in there now. And then ideally we can get them answered during today's presentation. All right, I'm going to take a second and talk a little bit about Startup Spring Training. So it is 3 weeks of free classes and resources. You have mentorship with amazing Arizona-based mentors, and all for the purpose of learning and potentially earning a microgrant. Our microgrants are $500 in non-dilutive funding. So that's a fancy jargon-based word for funding that you don't have to use for something specific. You can use it towards a trade show, branding, marketing, launching your website, really anything related to your business. We have about 100 of those grants. And so the faster you work your way around the bases, the closer you will be to potentially receiving one. All of our presenters are really curated from Arizona. This is an Arizona-based program, and we're really looking to focus on women and BIPOC founders or underrepresented founders here in Arizona who traditionally just don't have access to really wonderful networking tools, community, mentors, and education. So this is meant to be an inclusive program to help all parts of the state. All right, so just by being here, you are checked in. What does that mean? Well, you want credit, right, for coming to today's class. So when you registered via Zoom, it automatically gave us a tally and registered you. Now, I will say that we at SeedSpot are actively having to track and move you from base to base. So you will get automatic updates like emails and things like that. But please, please, please have some patience with us. It does take us a few hours or a day to get you around your base and get those credits made. But no, it is top of mind for us and we will get it done. Know that if in the chat you have any questions about how SeedSpot is doing this, please let me know. If you have, hey, Tristan, I didn't credit for something, please let me know. I'll also answer those questions as well. So today we are in the art of contracts. It is March 5th. If you want to see the full schedule, you can scan here or go to our website. It's in both English and Spanish. We have both in-person and virtual classes. But enough from me. Let's get on with the real talent. Everybody, welcome our speaker. Yay!
Hi, everybody. Thank you so much for joining. I know Wednesday nights at 6, it's middle of the week, it's late, it's after the workday. So I just want to start by thanking all of you for being here, making the time, and really putting the time into you and your business. So just thank you for doing that. And also good job if no one's told you. So we'll get started. I always like to introduce myself so that way you know why I'm here talking to you, and a little bit of my background. So my name is Krizia. I am the owner and the founding attorney of the Launch Law Firm. The Launch Law Firm has been around for about 2.5 years. Prior to that, I worked in big law. So think if you've seen the show Suits, that's what I worked in, except it was a lot less fun. But that kind of vibe. So when I did that, a lot of my clients were Fortune 500s. I also represented startups, everyone in between during that time. And I was primarily a litigator, meaning I went to court and I argued for a living every single day. So what I saw a lot was things going wrong in business. That's really when things came to me. Something went wrong. Someone wasn't getting paid, doing what they were supposed to do. And they came to me and then I went to court for them. And then doing that, I was networking, teaching things like this. And I was seeing a lot of small business owners coming to me with issues, those same issues. I'm not getting paid. Someone's not doing what they said they were going to do. And some of the first questions I would ask are, okay, let me see the contract you have. Let me figure out what information you have about your LLC. Let me see kind of all the basics. And a lot of times, small business owners, new business owners didn't have those things in place. And a lot of times what I heard is I didn't know. Or I didn't know where to start. And so then I was like the grim reaper of the law, having to tell them, okay, we don't have a lot of good options now. Your options are pay what they're wanting you to pay, which maybe you don't need to, or you wouldn't have to if you had that contract. You can pay me a lot of money to argue on your behalf and potentially still pay them money, or you can just decide to walk away and just let it be if it was something you're owed, or sometimes even worse, we were talking about filing for bankruptcy for their business because there just wasn't the money to do it. So when I started my firm, I was like, you know what? Someone has to go out here and tell people, here's things you're maybe not thinking about that you need to do. Here's how to avoid issues. So that way you're protected down the road in the future. And that's how I started my firm. And one thing I also like to tell people in all my presentations is I'm a lawyer. Yes, I am, but I know a lot of times there's a lot of intimidation about the law, about lawyers. We kind of get a bad reputation for maybe not being the kindest humans around. But I like to remind everyone I am human just like you. I'm also a small business owner just like you. So when I'm not being a lawyer, I'm like a chronic animal lover. So I have 2 dogs, a cat, and I normally have some injured animal that I have found either in my neighborhood or around that I am nursing back to health. So that's me outside the law. And like I said, I'm also a business owner and a founder like you. And so I know all the different hats we have to wear, all the learning that goes on and just figuring out how to run your business. So let's get into it. Here's kind of high level things, what we're going to talk about. Today's presentation is contract based. So we'll talk about how to form a contract, some key terms for you to look for, how to enforce your contract, and my favorite part, go over some negotiation tips because I love getting a good deal, whether that be for my clients, whether that be I'm buying a car, whatever. So I'll give you some tips and tricks on how to be an expert negotiator, and we'll leave some time at the end for any questions you have. But if you do have any questions, please feel free to put them in the chat, come off mute. It gives me a chance to take a break, answer questions. So if you have them, let me know, and I will answer them as we go, or you can hold on to them at the end. So first, the big question, why do contracts even matter? Why should you care? So first, I love they create clarity for everyone as to expectations and responsibilities. Okay, I'm agreeing to give you $100. What are you going to do in exchange for that $100? Are you going to organize my kitchen? Are you going to do what? I want to be clear about what I'm giving you and what I'm getting in return. 2, it provides you with legal protection. So if I give you $100 to organize my kitchen, I have something to say, hey, I gave her $100. She's going to organize my kitchen. And if you don't, I have something to go to the court and say, here's what we agreed to. Here's what didn't happen. It establishes a professional relationship. And so I hear a lot of times like, oh, I'm afraid to use contracts because it looks so serious. What's going on? And I will tell you that is a red flag. That I always tell my clients not to worry about. If someone is concerned about you using a contract, you probably don't want to go into business with them, because everyone should like a contract because, like I said, it gives you that clarity of what everyone's agreeing to and gives you something to go back to in the event something goes wrong. And then finally, it gives you a clear document to reference in the future. So maybe some of the relationships you're going into with your business, maybe it's a year long, 2 years long, maybe longer. You want something that documents that both of you can go back to, all the parties can go back to and say, okay, when we originally entered into this agreement, what did we say we were going to do? Okay. And then this is a little bit of the legal side of it. So how do we form a contract? And what do we look at in the law for contracts? So first, a contract is a legally binding agreement between 2 or more parties, and it creates legal obligations or obligations that are enforceable by law between the parties. And so this is the little bit of a legal side. This is your contracts 101 from law school, if you will. So these are the basic elements that we look for to determine if there is a contract. And so the things that we look for is offer. So that means I'm offering my services and I'm putting it out there for whoever I'm talking to accept them. The second part is there has to be an acceptance. So just because I make an offer and say, hey, I'm willing to pay you $100, for this, you have to accept it and say you agree to do it. So we have offer, we have the acceptance of that offer. Consideration, that means we can't enter into a contract that just says you're going to give me $1,000, period. And I'm not getting anything. There has to be something that we're exchanging. I have to be giving and getting, you have to be giving and getting. So we're looking for both of those things. It can't be just a one-sided. That goes to the mutual obligation. Both of us have to perform something, whether that be giving money, whether that be giving services. If you think of like NDAs, non-disclosures, it's I'm agreeing to keep quiet. I'm agreeing not to do something in exchange for money or in exchange for the privilege to go into this event. And then finally, competence and intent. So you can't enter into a contract with someone who's under the age of 18 because legally they are not competent, meaning they don't have the mental capacity yet to enter into a contract. Just like you also can't enter into a contract with someone who is drunk or under the influence of something or has, a mental illness that makes them not fully able to understand what they're doing. And so you want to look and make sure when you're doing this that the person's over 18, that's kind of the big one, but also you'd want to make sure that there's not something, that they're all there and know what's going on whenever you sign the contract, or else down the road, a court could find that's not enforceable if there was something keeping them from fully understanding what they were entering into.
We have 2 questions presently right now.
Yes.
And so I really believe in people having a chance to like use their voice to answer the questions or ask rather. So Luis, can you come off mute? He had some trouble.
Yes.
There he
Yeah.
is, Luis. All right, give us context and ask your question, please.
So I was in a class earlier on for law, 10 biggest mistakes small businesses make. And in that class, they said something that kind of caught my ear about your when you have someone working on a logo for you, that you need to have them to like sign the rights of that logo over to you. So I don't know what kind of agreement that would be. So is there like a specific agreement that where if someone's creating some kind of, I guess, I don't know what you would call it, intellectual property or something for you, that they would sign those rights over to you?
Yeah, so it can be called multiple things. That's the fun part about the law is I can call an agreement whatever I want to. But generally what it's called is a work for hire agreement. Um, or like you also might see it called like a services agreement. Like if you're getting it from the person that's creating a logo, they just might call it a services agreement. But what you want to look for in either the work for hire or the services agreement is you want to look for something that's an assignment of rights. And so somewhere in there, even if it's a service agreement, you want to see the language, this is considered a work for hire. That's intellectual property language that says essentially you're paying me to do this and I'm giving the rights to you in exchange for the money you're giving me. But that's what you want to look for. And yeah, exactly. And you would do that for people who are creating logos. If they're drafting like website copy for you, if you have an independent contractor who's like creating like computer programming or anything like that, you want them to assign those rights because under intellectual property law, once you create something, like I own it by creating it unless I've assigned my rights to someone else.
Gotcha. And is that I'm currently in talks with someone doing that. So should I do that at the beginning before we even okay.
Yeah.
So not
Yep.
before payment, but before we even get any work done.
Yeah, I would do it before you hand them a penny. I would have that in the initial negotiation that says, okay, you're creating this logo. I'm paying you $1,000 for it. And in exchange for that, like, I want you to work all of that out at the very beginning before you exchange anything. If you've already paid, not into the world. But I just think it's easier at the very beginning before anyone's taken one step one way or another, agree to everything, get it in writing and get it signed.
Thank you.
And
Yeah.
just a follow-up question, if you're using a contractor like our platform like Fiverr, would you give the same advice for, kind of outsourced work like Fiverr?
Yes, I would. Fiverr and like Upwork and things like that are interesting, only because a lot of times the people that are on there, some of the people on there are from other countries, which adds a little twist into it. But I've had a lot of clients go onto Fiverr or Upwork to do different things. And I always tell them like, whoever you are contracting with over there, again, shouldn't be intimidated by you saying, I want to get this in writing. I want the contract, especially if it is things for like logo design or things like that, because at some point, hopefully you're going to want to go and register that trademark, register that copyright. And whenever you make those applications, you have to make a representation that says either I created the work or I have rights to the work that's created. And the way that you have those rights is through some written agreement where those are assigned to you.
Okay, we've got a follow-up question from Deborah A. Deborah A, are you here?
Yes. Oh, I have to read it.
I want
Okay.
you to ask Yeah.
Okay, well, I guess do you have any recommendations for setting up non-adversarial? I know a colleague of mine calls it conscious contracts as opposed to traditional business as usual contracts that are about covering your ass. Just curious if you know of anybody here locally, because my colleague is on the other side of the country and I'm interested in being able to use those.
Yeah, so I think one, it comes down to you having it drafted. So like I can draft, like when my clients come to me, I have a conversation with them that's like, okay, who are we dealing with? What are we wanting to do, right? Are we just wanting to protect ourselves or are we wanting things in there? And every contract should be some negotiation. So to the extent that you're even receiving a contract, I never want any of you to feel forced to sign it as is. Like every person has the right to come in and say, okay, I'm fine agreeing to this, but I also need these protections. And so if in that situation you're wanting to make your contracts less adversarial, obviously there's some things in there that say like, okay, you're going to pay money, I'm going to do these services, but a lot of the provisions that are in there, you can make them mutual. And that's just changing around the language that's in there. So like indemnification, for example, is one that's who's going to be responsible for paying a lawyer or paying damages in the event something goes wrong. I always like generally making those mutual because if I mess up, I think I should be the one paying for it. Just like if you mess up, you should be the one paying for it because I shouldn't be responsible for your mistakes, just like you shouldn't be responsible for mine. Confidentiality should be mutual. So there's a way to make any contract beneficial to all parties. And I am a proponent that 98% of contracts should keep both parties in mind. A lot of times what ends up happening though is like a fear of negotiating or a fear of saying, hey, if I come in and I want to try to negotiate, they're going to say no and go find someone else. But I think a lot of it comes down to, like I said, negotiation or at least communicating. That's how you want the contracts drafted.
Okay, thank you.
Mhm. Do we have any other questions right now? No? Okay. So now we'll go into verbal versus written contracts. And this is something I always like telling people because sometimes we think a contract, we're thinking I have a piece of paper, but contracts can be verbal. So if we meet up and I say, hey, I'm going to give you $100, you're going to organize my kitchen and we handshake on it, technically we have a contract. Is that the best situation for us to be in? 0% no, it should always be in writing. But just know, like, if you have an agreement, like, as long as those four elements of that we went over at the beginning of what it takes to make a contract, there's an offer, I'm going to pay you $100. If you clean my kitchen, acceptance, we're of capacity, we are both doing something, all those elements are there, and that's all that it takes. There's nothing in those elements we went over that says it has to be in writing. So I always think that's important to know, but obviously, like I said, I want all of you to lean towards the written contracts. And that's because of kind of very clear reasons. One, they're more enforceable because they provide clear evidence of what was agreed to. Versus verbal contracts, I can tell you 9 times out of 10, if it comes to a dispute and you say, hey, Krizia agreed to pay me $100 and we're disputing, well, Krizia is going to come in there and say, nope, I agreed to pay her $10. And that's just how it works when you're in a dispute. The parties are going to have very different versions of what was agreed to. Two, the written contracts prevent misunderstandings. So we can go back and look and I can be like, oh, yep, you're right. I agreed to pay you 100. For some reason, I thought it was 10. Versus on the verbal, it's very difficult because it's going to be your word against my word. And it's going to be who does a judge or a jury find more believable? Was it going to be the $100 or the $10 in the example? And then I think it's also important to know in some very specific cases, you can't have a verbal contract. And so those out here, real estate transactions. So if you're buying or selling property, it has to be in writing. There's a legal theory called the statute of frauds that says even if we enter into a verbal agreement and say it, that contract's not enforceable because anything selling property needs to be in writing. Sometimes in some states, if it's contracts that are lasting longer than a year, if they're over a certain dollar amount, states have different statutes, or if you're selling goods, over $500, those need to be in writing as well. So that's just good to know. And then just some more little negatives on the verbal contracts is, like I said, it's going to be your word versus their word if there is a dispute. And so just know the cost associated with dealing with a contract dispute for verbal is going to be significantly greater than if you got it in writing. Okay, some common contract types that you guys might find in your businesses. So the first one is service agreements. So for anyone who is providing a service of any kind, you're going to want these for you and your customers. So your service agreement is going to outline exactly what it sounds like, the services you're providing and what you're getting in return from your clients. So what I would like to see in a lot of these is I want to see payment terms. I want to see how long the agreement's in place for. I want to see what you're agreeing to do. I want to see ways you can get out of the contract. I want to see your return policy. All of those kind of internal policies that you have should be in that service agreement, because this is what you're going to go back to with your clients. Next is the sales contract. So this is more for if you have goods or products that you're selling. So this is literally saying, I am selling you this cup. Here's what it is. Here's my representations. You can use this cup for cold water only, not hot water. Here's my return policy. All of that stuff should be in those sales contracts. So a lot of times, depending on the type of business you're going to either have a service contract or a sales contract that goes to your customers. If you have employees, you're going to want an employment contract with them. There's lots of different employment law stuff that can really trip you up as a business owner. So having that outlined as to what's going on, what your relationship is with your employees. Similarly, if they're not employees, if they're independent contractors, you again want an agreement saying what they're doing, what they're getting paid, and why they qualify as an independent contractor and they're not an employee. And then non-disclosure agreements. So those are NDAs. And this is the best way for you to protect kind of your business's secret sauce. So what are the confidential things that you don't want your competitors to know about? So an example I like to give here is Coke and Pepsi, right? They're competitors, they create very similar products, but each of them have some secret ingredient that makes Coke taste different from Pepsi and Pepsi taste different from Coke. And I can tell you right now, neither of those companies want the other one knowing what it is, because then they could duplicate it. And so the best way to do that is if I'm Coke and I have someone coming in, I'm going to make them sign an NDA, confidentiality agreement that says, hey, I'm going to tell you what our secret ingredient is, but you're going to sign here saying you're not going to go out and tell other people. And if you do, I can come after you. I can get monetary damages. I can force you to stop. I can make you give back stuff. So NDAs are how you really protect your secret sauce for your business. Okay, and then within those contracts, some key terms. And so I always tell people, ideally you have a lawyer review your contracts every time. I know in reality, that's not always feasible or doable and would also be very expensive. And so I always like to highlight, here's things that I always want you to have in a contract and I want you to be on the lookout for in a contract. So the first one is the scope. So this could be called scope, this could be called services, but it's essentially saying, what are you doing? For how long? What are your timelines? And all of that stuff. So anything that you're doing or getting, I want to see it in here. And one thing that I always caution people to be afraid or to be cautious of and watch out for is if I'm saying, okay, you're going to come in here, the agreement is, let's say you hire the firm. I'm going to draft you one contract. It's going to be 8 pages long, right? A lot of times what you see, and it's not intentional by the other party, but as you're going and you're working, hey, okay, could you also add in a page about this? Could you add in this? And mind you, I charged you a fee thinking it's going to be this 8 page. And now suddenly I've put in extra time, extra effort, and now we're at 20 pages. And you're getting 20 pages for a cost of 8. And so it helps you by having a clear scope. It helps you kind of protect for those situations. And it's not that you have to say no, but it gives you the ability to go back to them and say, hey, yeah, no problem. I'm more than happy to do that for you. Initially, we agreed to me doing X. For me to do this additional stuff, Y, it's going to cost an additional amount of money. And it really makes having those conversations easier because you have something to point to versus if it's unclear and it's like, okay, I'm going to draft you a contract. Okay, is that contract 1 page or is that contract 1,000 pages? It's not clear. And then if I go back to you and say, hey, I'm wanting more money, you're going to be like, well, it just says a contract. You didn't say how many pages. And so I want your scope to be very clear. So that way you can prevent that scope creep and be clear and have the ability to go back if it is exceeding what you initially agreed to. The next thing I like in there And no matter your contract, it should have it as payment terms because we are all in business to make money. I'm sure like I love what I do, but at the end of the day, I also have bills to pay. I need to get paid. I need my clients to pay me on time. And so having this payment terms in there, it's really interesting because this gets left out of contracts, probably one of the most frequent provisions that's left out, which is crazy to me because we're doing everything else in the contract, but we're going to leave out how we're getting money. So I want your payment contract terms to have the amount that you're getting paid, how they're going to pay you. Can they pay by check? Can they pay by cash? Can they do Venmo, Zelle, all of that stuff? If there's a schedule, are they paying you on the 1st of every month, on the 15th? Is it one lump sum? I want all of that to be in there. And I also want you to include a provision that says what happens if they miss those payments. Are payments due on the 1st? Okay, at what point does your late payment fee come in? What is it? Is it a $5 fee? Is it 15%? Can you then cancel the contract if you don't get it? I want you to have some teeth in there a little bit. So that way, if you're not getting paid, you can go and say, hey, I have a 3-day grace period. You're at day 2, you need to pay, or there's going to be a $50 late fee. Yeah.
Two things real quick. One is Sonia. Sonia, you want to come off mute and talk a little bit about the question you have around logo verbiage? She might not be able to get off mute, so I'll read it for you. Would you be able to repeat the name of the verbiage that should be included in the logo rights for my contract?
Yeah. So what you're going to look for is that work for hire. So it's going to state, this is a work for hire. And as part of that, all right, title, and interest are transferring to whatever your company is what you're going to look for. But the big language is that work for hire.
Thank you. And the second thing is, this is not the context of talking about contracts, but for many of you, can I see a show of hands? How many of you are new to business? You've just started a business out. And so you've been doing this thing for free. So you can either hold up an emoji hand or show me your physical hand. So I think oftentimes when it comes to payment and payment terms, we underpay ourselves because we're new here. So one thing I would suggest in the terms of your contract is to pay yourself fairly or to identify what is fair for the contract. And it doesn't matter if you've been doing this skill, let's say, of organization for a week or for 75 years. At the end of the day, your time and talent is worth something, right, in the marketplace, and your contract should reflect that. Just as an FYI, because this takes a lot of time and energy, and you want to be able to sustain it. Sorry, just my 2 cents before.
100% agreed. And, I was listening in on another session. I think it was yesterday morning about like cash flow, and it was with some bankers from Chase Bank. And they actually gave some good advice that I was like, that's really good advice that they gave. And they were saying, there's different ways for you to do market analysis, but like that helps with everything with the cash for your business of being like, okay, for my organization services, the going rate, if I go look at my competitors' websites, it ranges between 50 and 80 bucks an hour. Knowing that is so powerful, especially for creating your contracts of being like, okay, if I'm selling my services for 20 bucks an hour, yeah, business is going to be booming, but my 3 jobs is going to equal 1 of theirs. So does that like make sense? So I just think it's so valuable just to go do research and like stalk your competitors a little bit and see like, what are they doing? What are they charging? How are they grouping things together, and use that as a basis? And that doesn't mean that you have to match them or you have to beat them. But if okay, I'm starting out and I do need to build my, book of business, and maybe everyone's charging 50, but I'm going to do 40, right? And until I get that book, and then I know I'm going to bump it up to 50. Just having that knowledge and kind of growing your business and developing your business is extremely powerful. So do that. Okay. The next one, term and termination, another provision needs to be in there. So term, meaning how long are we in this agreement for? Is it a month long? Is it 6 months? Is it a year? Is it 10 years? How long are we agreeing to do this for? And then termination, another one that gets left out a lot, but how do we end this agreement? We're not getting along. You haven't paid me. I finished my services, whatever. What does it look like, and what are the means that we need to do to get out of it? Maybe we have a year-long contract and it's not working out. Okay, do I have to give you 30 days notice before I cancel, 60 days? All of those things you want to look at, because you always want something to be able to pull that like emergency door of like, okay, I need to get out of here. This isn't working. You need a plan for that in your contracts and have a method to do that. Okay, some more key clauses. So confidentiality, non-disclosure. We talked about that with the NDAs. You can also include the same language in your bigger contracts. So if you are, a service provider and you're going to be providing a lot of proprietary information that you've created, you can put that in there and say, hey, I'm giving you this. You're agreeing to use it just for this purpose, for our coaching, for whatever, but you can't go and turn it around and now sell it as yours. Because people will try to do that. They will try to steal what you've created, and then next thing you know, they're going to be your competitor using all the stuff that you created. So have some stuff in there that says this is confidential and protects everything that you've created. Indemnity, we touched on this, is the indemnification provision that says who's going to be responsible for what. So if I mess up, I should have to probably pay for the damages, for the lawyer fees, for all of that, even if they sue you. Because if they sue you because of a mistake I made, I should have to come and say, okay, yep, I got you. This was my bad. Just like you should probably do that if you mess up something and they end up getting sued by someone. Indemnity, or the indemnification, it could be called, is where this happens. What I want you to be on the lookout here is a lot of contracts will be unilateral, saying you're going to indemnify me for everything related to this agreement, related to your services, regardless of what I did. We do not like that. We do not want that. You should every single time push back on that, because if I'm over here being crazy, breaking the law and doing stuff, you don't want to be responsible for that. That's on me. I'm the one acting negligently. I'm the one that's breaking the law. I shouldn't have to be able to point the finger to you and be like, okay, yep, I completely was wrong, but give me the money. Reimburse me my attorney's fees. And so be on the lookout in those indemnification provisions for something that makes you take on all of that risk. Next is governing law. This is important because a lot of times, especially as your business grows and you start working with companies that maybe are outside of Arizona, they're going to have provisions in here that says what state law is going to apply. So different states have different laws, different things may have different limits, different requirements, and ideally you want it to reflect the state that you're in. So we want to see it here in Arizona because we know Arizona law. And the other part that plays into this is sometimes in here you'll also see it's called venue, jurisdiction and venue. So that means if there's a lawsuit, where does it happen? So I see contracts all the time that clients have entered into, and they're based here in Arizona. Everything is here in Arizona. They have no offices, no people anywhere else, but they've entered into a contract that has governing law, jurisdiction, and venue in New York. Well, that means now the lawsuit is filed in New York. They have to hire a New York attorney. If there's hearings, if there's all that, they're flying out to New York. Potentially the people, the jury, the judge might know the company because it's New York based versus knowing you. So there's just a lot of negatives and potential expenses if you have this different. So just be on the lookout for it. And that doesn't mean don't agree to it. Like maybe sometimes there's a really big client that's that game changer for your business and they want it to be New York. Okay, well, at least be aware that if something goes wrong, you're going to New York, but weigh that cost benefit of this is my ideal client, the big whale client that I've been waiting on. Okay, I'm willing to give on this, but just be aware what law is applying to your agreement. Next is dispute resolution. So this will outline what you guys do if there's a dispute. Things that I like to see, an arbitration provision or a mediation provision. And these are just other ways that you can solve a dispute without having to go to actual court. Why do you want to do this? One, it's cheaper. Two, it takes less time. If people come to me and we're going to file a lawsuit in Maricopa County State Court, I can tell you right now, best case scenario, it's taking a year. Most realistic scenario, 2 years down the road is when we're actually getting in front of a judge or jury for trial. Takes way longer, way more money. If you're going to take something all the way to a judge or jury trial, you're looking at a minimum of $50,000 just in lawyer fees. That's a minimum. If you have an arbitration or a mediation provision, you can dictate when those happen. So you can say, hey, mediation, we're going to have 6 months, and we're going to go to mediation. Mediation is where you have a neutral third party who goes back and forth between you two and tries to reach an agreement. So a mediator is going to come to you and say, here's where I think your case is weak. Here's where I think you have good facts. They're going to go to the other side, say the same thing, and try to get you guys to meet somewhere in the middle, but they're not going to make a final decision. They're just going to help you reach an agreement. Arbitration, think like court. You're going to have a neutral third party. It likely won't be a judge. It's probably going to be a lawyer, or there's some people who aren't even lawyers and are just arbitrators and do it for a living. But you're going to go and you're going to present your case to them just like you would in court, and they're going to reach a decision. That decision is going to be binding. Arbitration, you can get before an arbitrator much quicker. You can really limit how long each party has to do stuff. If you came to me and you didn't want to do discovery and all that stuff, we could probably get in front of an arbitrator within a month. So you're looking at 2 years versus a month. Most times if there's arbitration provisions, we're doing that within 6 months. We're giving some time to go back and forth between the parties. 6 months will be in front of an arbitrator. Okay. Red flags. What else should we be looking out for? So first one, vague or ambiguous language. Remember, like when we talked about scope, I want you to be detailed. How many pages, how much this, how much product, what's your timeline? So for example, something that is not great. Service provider, you put your company in there, will deliver work in a timely manner. We could probably take a poll right now and all of us are going to have a very different time frame expectation in our brain of what a timely manner is. For me, I like to get things done. A timely manner is a week or less. For someone else, it could be 6 months. So instead, you want to have a specific daytime or period in there. Service provider will deliver the work within 14 business days. Cool. Now we know we have 14 days. Day 15 of the business day, we're in breach. We're all in agreement about what that is. Second one is having unfair or one-sided terms. So an example of that would be client may terminate this agreement at any time without cause, but service provider must give 90 days notice. Okay, I can come to you and say, we're done today. Too bad, so sad. You have to give me 3 months. That's not fair. Ideally, you go back and negotiate and say, hey, you know what? Let's both have to give 90 days notice before we terminate. And then same thing, looking for unequal rights and obligations. So that goes for that confidentiality or indemnification, things like that are what do you want to look for? We want those to be equal. Third, missing or incomplete clauses. This happens a ton because most business owners, myself included, pretty much all my clients, we have a form contract we're sending out all the time. So I always tell my clients whenever they get a contract from me, I want you to make at least 2 copies of whatever contract, and one is going to be your master service agreement, master whatever, and you do not touch that one. That's your go-to. You can make copies of it, you can do whatever, but you don't edit it. Maybe then you have another one that says, okay, this is my 1-year term contract. That's that master, and you edit it that way, because what happens is sometimes we go in quick, I need a contract for a client, I pull the last one and I forget I took out 3 provisions in this one for whatever reason. Now I'm behind. Or I have blanks in contracts. And I see this more times than you think. Client agrees to pay blank amount of dollars for services and we never fill that in. All the parties sign. Down the road, you're in a dispute. Lawyer looks at the contract and says, there's no payment terms in there. What were they supposed to pay you? It's blank. Oh crap, we forgot to fill it in. It's a blank that needs to be filled in. We forgot. So just make sure everything that you want to be in your contract is in there and any blanks that need to be filled in are filled in. Next one is unreasonable penalties. So late fees, for example, are a good one. Most of the time what I see for late fees is about a $50 late fee or 1.5% of whatever the contract amount is. Now, if you're seeing a late fee that says, okay, you're doing this and after 5 days, it's 50% of your contract amount, probably unreasonable, and you want to negotiate that down. So just make sure any fees, penalties, things like that make sense. Okay. The next one, a unilateral or one-sided right to modify. So allowing one party to change the terms whenever they want without getting the other party's consent. Every agreement should have a provision in there that is called amendments or changes or something like that that says, if we're changing anything in this contract, it has to be agreed to by both parties, and we have to sign an amendment or something reflecting that change in writing. I want to see that in every single one. The unlimited liability. So that's going to be in that indemnification. It could be in other provisions. I always recommend if you're reviewing it on your own, Control F your contract for words like unlimited, liability, things like that, to see if there's anything unlimited, unrestricted. That's probably a huge red flag, and you want to read that sentence very closely about what is unlimited. But you want to make sure that any liability you have is capped. What I try to negotiate for my clients is, in the event something goes wrong, I want to put a ceiling. So damages are capped at $2,000 or the cost of services or goods provided, whichever is greater. So we know we have a $2,000 cap, or if they paid you $10,000 and the most they can get is $10,000, that's a good way to limit your liability and exposure in the event that something does go wrong. Next is the unclear payment terms. So we talked about this too. We want to have a timeline exactly laid out on the first of every month. Here's the amount that's due. You get this much grace period, whatever. We want to be clear, not have vague terms. And then you also want to be careful of your payment terms of them being tied to something happening. So, I'm going to give you $100 up front, and then if the sun comes out next Wednesday, I'll give you another $100, right? That's a silly example, but we see things like that in contracts where it's like, okay, if and when this happens, then you'll get this. Be very careful about you getting money tied to something that you have no control over. And then this is similar, Luis, to your question that you asked. I want you to be on the lookout for intellectual property ownership transfer. So just like you want to get people to transfer their intellectual property rights to you if you're hiring them to create something, you want to be careful that you're not transferring your rights to people unintentionally. So is someone hiring you to build something or to create something, you want to make sure if you're transferring your rights, you want to be compensated for it. There's a very different monetary amount that I should be paid for, letting you use programming that I did, but it remains my ability to use it again for other people, versus I'm creating for something for you and then you're becoming the owner and now you can license it out. Those should be two very different payment amounts, because essentially one, I'm licensing, giving you the rights to use what I've created. One, I'm giving you ownership. So I want you guys to be on the lookout for that and make sure if you are transferring your full ownership and rights to someone, that amount that they're paying you needs to be up there. And then making sure that they're clearly defined, your intellectual property things. So things like your trademark, so your logo, your brand, your slogans, I like seeing in there, when can they use it? If I'm partnering with you, when can I post your brand name all over my social media and say, hey, approved by your company name, put your logo on this, right? You may not want that. You may not want my law firm being able to put your logo everywhere and essentially tap into your customers, and your customers be like, oh, okay, Luis's company uses here, they must endorse it. It's great. You want to have very clear what they can use, what they can't use, what their rights are as it relates to the intellectual property that you own. Cool. Contract enforcement. So this is another one. It's uncomfortable. Disputes are uncomfortable. But you can have the most perfectly drafted contract in the world, but if you don't enforce it, you might as well not have a contract. And it's awkward. I get it. It sucks to go to someone and say, hey, you were supposed to pay me. We agreed and you haven't. You need to do it or I'm going to take you to court. I mean, you can phrase it much better, but that's essentially what you're saying when someone's violating a term of your contract. And in your contract isn't going to go out there and enforce itself. It's not a magic wand that once it's signed, it's going to go knock at the door for you. You have to be the one to know what your contract says, and you have to be the one to say, hey, here's what we agreed to, follow it. So the best way to enforce your contracts is, one, keep detailed records. So keep a copy of the signed contract. I want you to have an organization system where if I tell you tomorrow, hey, I want to see your contracts with all of your clients, you know exactly where those signed versions are. It should not be an Easter egg hunt for you to find the contract that you need when you need it. If things change, if there's a communication where you say, hey, it's okay if you deliver this a week late, or I'm going to deliver a week late. I want you to save that. I want you to save that email. I want you to save that notice, and I want you to put it in that same folder. because you have the contract. And if we agree to extend it out, I want you to be able to pull that again in the event something happens. And I want you to create a paper trail. So again, maybe we have an agreement and I call you and I say, hey, is it okay if instead of doing this next Monday, we do it the following Monday? Yeah, sure, no problem. I want you to follow up with an email. Krizia, so great talking to you. As we agreed, we're now moving, from this Monday to next Monday. I want you to put all of that in writing. So that way, at the end of the day, if there's a dispute, you have something showing here's what we agreed to, and you have that paper trail and you can enforce it later on or defend yourself. Nope, we agreed to move it, right? I want you to be a clear communicator. Again, it's uncomfy. Maybe things are going wrong. Maybe they're not quite delivering. The quicker and earlier on you can have that conversation, the easier it's going to be than if you let it bubble up, bubble up, bubble up till it's a really big issue. So if I hire someone to paint my house and we agree that they're going to paint it blue and they start painting and I see that it's gray, I should probably go out there as soon as I see the gray paint and say, hey guys, not what we agreed to, blue paint, you're using gray, versus letting them paint my whole house and being like, you guys painted my whole house the wrong color. They're probably going to have a much poorer reaction to that than if I catch them very early on. So just go out there, tell them right away, like, here's what's going on. Here's where we're not meeting expectations. My understanding was, you were going to be here 3 times a week. You're only coming 2. How can we fix this? The earlier you can do it, the smaller the issues tend to be and the easier the conversations are, and the more you're able to salvage the relationship. And then third, review your contract terms and comply with them. Especially if you're in long-term contracts, it's really easy to sign it and then forget it. I always recommend, depending on how long it is, doing at least quarterly contract reviews, for sure yearly if they're extending multi-year contracts. But look at it and just say, okay, are we doing everything that we said we were going to do? Are they doing everything they said they were going to do? And it's a good time, again, to catch those things early on, rather than getting towards the end of the road and be like, oh my gosh, I completely forgot we agreed to do this and it just didn't happen. So review it with some frequency just to refresh your memory as to what is agreed to. Okay, what to do if a contract is breached is first figure out that there was something not done right, communicate it. If it needs to be in writing, put it in writing. Figure out if mediation or arbitration is a good way for you to solve it. And then to the extent that those aren't good options, and you can't reach an agreement on your own, proceed with legal action. So legal action doesn't always mean a lawsuit. You can send a demand letter, essentially a letter from a lawyer saying, hey, you messed up, hey, we're going to do a lawsuit. Small claims court, if it's under $10,000 in dispute, is an option that's cheaper. Formal litigation for bigger breaches, and then you can kind of go from there. Negotiation strategies. So these are just some things that I do when I'm negotiating for my clients, when I'm negotiating in my personal life and everything. So I just think it's some good reminders and tips. So the first is being prepared. So I always want you, before you go into any negotiation for your business or yourself, to know what's expected. What's the industry standard? Think to yourself, what are the things that I need to have? And what are the things that I want to have? And what are the things I really don't care about? If I get them, great. If I don't, great. Have that list before you even go in there, because that's going to help you keep a clear mind and avoid making those emotional decisions, and make those more logical decisions. Next, BATNA. I learned this in my law school negotiation class. There's a lot of books like Getting to Yes and things like that that talk about this, but it's your best alternative to a negotiated settlement or negotiated agreement. What does that mean? We don't reach an agreement, what happens to me? And we don't reach an agreement, what happens to you? So, for example, I recently sold a car. I didn't need to sell the car. It was sitting there. So my best alternative to not reaching an agreement with someone who's coming in and trying to offer me way less for my car, I keep the car. Okay, someone else will come along. I don't need it. Their case, maybe they don't have a car. So their best alternative is they are taking the bus. I know I have leverage in that negotiation, and maybe they know they are coming from the weaker point, right? And so just knowing what can happen if we don't reach an agreement, and that helps you kind of know your leverage in the negotiation and how hard you can push. Effective communication. So one, some of the best communication is zipping your lips and listening. Maybe we are trying to negotiate getting my house painted, but then I hear you talk about how your wife just got in a car crash and my husband happens to do body work. 0% to do with doing my house painted, but maybe I can try to tie in a deal. You know what? 10% off if we can drop it down, right? That I got that through listening. That has nothing to do with my negotiation, but just by listening to you and talking to you, I've learned something else I can offer as a token. And also, I want you to, ask open-ended questions. Okay, what are you looking to get done here? What's a way I can make this easier? Rather than, okay, do you want blue or yellow? Right? That gives them one answer. Maybe they want pink, right? You don't know that. What color do you want? Open-ended questions, not yes or no, is going to help you learn a lot more and be able to strategize better. And then tactical concessions. I love this one. It goes back to that preparation. What are the things that you don't care about? If you get them, cool. If you don't, cool. Maybe I don't care if they give me daily updates. Maybe I just want weekly updates. But we start out with daily updates and they're like, oh man, daily updates is a lot. What if we could do weekly? And I'm like, oh, yeah, I'll agree to weekly updates if you can drop your price a little bit. Right? That cost me nothing. I already didn't care. I just wanted weekly updates. We were starting at daily. I know that, but now I've been able to give them something, give them a win, and use it to help me get something I actually want. And then if then statements in those tactical concessions, like I said, okay, if I agreed to let you do weekly updates instead of daily, then I want you to do X, tying it to that. So I don't want you to give anything up if there are still things on your want list. I want you to, if I give this up, then you're going to give me this and we can meet in the middle here. That's a great way to negotiate and to get more of what you want in your negotiations. Some mistakes I see in negotiation. Being a jerk is really that first one. I can tell you, I am way more likely to reach a better settlement with someone when they're being kind, when they're being a human, than when they come out and say, your position sucks, your client sucks, they're liars. I'm like, well, now I'm in the defensive. So we're probably not going to get that far. So be assertive, but be kind. Remember, your goal in negotiations is hopefully to build a relationship with people. So keep that in mind when you're negotiating. That doesn't mean don't advocate for yourself, but I always lead from a place of like wanting to understand what they want. And I want all of my negotiations to be a win-win for everyone. Ignoring the fine print. So we reach an agreement, things get added in there. I want to know what's in there. I want to read it. I want to make sure I understand it. I want to make sure nothing is getting slipped in at the last minute. That does happen. Failing to address any risks, assumptions, things like that. Talk about the hard things. Don't just talk about the easy, rainbows and butterfly side of it. Sometimes you have to talk about the hard stuff. And then don't rush. Sometimes even I am in negotiations and I feel my emotions bubbling up. I know what that feels like for me. I feel it in my chest. And that happens and I'm like, ooh, I'm having an emotional response right now. You know what? Let me take 5 minutes, let me take 15, maybe let me take a day. And then let me come back again when I have a clear head and I'm not, and I can actually think about what I want. So don't feel pressured, take your time, make logical decisions, and don't let your emotions lead. Best practices, and I'm running out of time, so I'm speeding through this. Create a contract system. So like we talked about, have folders, do all of that stuff where you can keep your templates, keep your resources, keep all your signed documents. Before you sign every contract, I want you to read it. That sounds basic, but the amount of times people come to me and say, I don't know what it says, I didn't read it, I just signed, makes me want to tear my hair out. Read your contracts before you sign them. Make sure you understand everything. Make sure the other party has the authority to sign, and make sure everything is filled out and attached. After signing, make sure you're keeping it. Communicate what you've agreed to with people. Document modifications in writing. And then again, when things go wrong, we kind of went through that process of how to handle the breach earlier. Whew, okay, a little bit about my firm for you guys. I do contracts, but I also do other stuff too. So I help businesses out with entity formation. So that's creating your LLC, creating your corporation, things like that. I do help register trademarks and copyrights, draft contracts, obviously, and also just help with general legal business advising, what to do, what you need, things like that. I also have a second company that's tied to it, that's called the Launch Plan. On there, I have a lot of attorney drafted contract templates that are at a lower price point. And I'm also working on kind of creating more like courses just to help small business owners figure this stuff being the legal stuff, side of their business out, without necessarily having to go and pay the lawyer price tag all the time. So, would love to keep in contact with you guys. Those are my business websites. I'm on Instagram. I post on there a lot of updates, stories, things like that. And I also do workshops like this, the first Wednesday every month at this time. So I welcome you guys all to join that as well. And some questions if we have them.
I want to thank you for joining us this evening, for providing us with some great insight and awesome dialogue. Big thank you to everybody who participated and asked questions. It just makes the session way more fun for everybody, for you, for our speakers. So big thank you to everybody who is here. Keep signing up for classes. Even if you rounded all the bases, keep taking classes and learning and connecting. Thank you everybody for logging on this evening. Enjoy your nights and we'll see you soon. Take care.